Okay, we are looking here at the 2011 Law Paper 1 for Law Unit 1 Public Law. Let us have a go at it. Now, the law papers, paper ones, just like most other paper ones for the humanities and some other subjects, have a lot of interpretation to the questions, and interpretation may shift the view. So I may put answers for questions that may not be the best for other persons from their point of view. So I would like you guys to just go down into the chat and dispute questions or dispute answers that I put. If you feel like it's another answer, right, just tell me, just write the number, the answer that you think should be the right answer, and why, right? And just support it, and we can have a conversation in the chat. Please do this for all the different law papers. I'm going to start from 2011 going upwards. All right, so we're starting first. The basis of legal systems in the Commonwealth Caribbean is common law. So I noticed that most of these are marked, but I'll be going over them, making sure that everything is fine for you guys. Philosophers who argue that there is an absolute standard against which all law can be measured are best known as the naturalists. That's true. The rule of law on which judges base their doctrine is referred to as the ratio decidendi, because remember, it's a reason for deciding something or a case. The rule of statutory interpretation, which seeks to avoid the most unjust and absurd results, may be described as the mischief rule. Statement of law made where a case is not fully argued, or if it's not fully argued, right, or where the court seemed to misunderstand the law or was unaware of relevant policy considerations, form a part of per incurriam, meaning that you're going to basically redo it. That was an error that occurred with the law, and you redo it. The supreme source of law in the Commonwealth Caribbean is the written constitution. Which of the following is not a feature of High Court or the Supreme Court? Alright, we're looking at this. They do not perform investigative functions. They can act as appellate jurisdiction. Well, they do have appellate jurisdiction. Judges adjudicating on matters before the court, they can. And trial function, okay. An advantage of alternative methods of dispute resolution, ADRs, is that they're fair, not necessarily bring the clients closer, not necessarily don't require parties. No, it would be that they're more cost effective. Number 9, which of the following is not an equitable maxim? Right, equity does not follow the law. Equity seeks to soften the law. Please remember that. All right. 10, which of the following is not fundamental to the classification of law? Right, so concept, function, and subject matter, not jurisdiction. Right, so these seems fine so far. Mr. Lickle, the foreman of the jury in a well-established case, met with Mrs. Dover, the mother of the defendant. The mother of the defendant, we can see a clear relation. He promised that if she paid him that amount of money, he could influence the jury to secure her son's acquittal. As a consequence of his action, Mr. Legal could be discharged from duty. He could be fined for his behavior. He could be arrested as well and criminally charged for perverting the course of justice. True. Zinga, a victim of domestic violence for 25 years, has been charged for killing her abusive husband by putting poison in his food, right? So charged for killing, this will obviously be criminal. Magnus is accused of setting fire to the house, right, he and his ex-wife occupied. He confides in his attorney, so confidentiality is brought into question there, Mr. Stewborn, that he did it because he said, I would prefer that none of us get it. He insists on pleading not guilty. Mr. Stewborn could, right, agree with Magnus's decision and continue with the case. I believe that this makes a valid point, a valid decision, right? I don't think you should decide to tell his wife, and I don't think you should decide to tell the prosecutor specifically because of confidentiality. But I think that you should insist that Magnus pleads guilty if he continues with the case. Right? I believe that ethically you should insist on continuing if he tries to continue the case, right? But I would believe that if he is stubborn, right, then you would probably continue with the case regularly, right? So it's based on your interpretation of the ethical standards as well as the standards of the legal profession and confidentiality there. Right. 14. Which of the following are features of delegated legislation? So in delegated legislation, it won't be flexible. It's actually more rigorous to have delegated legislation, right? Providing greater autonomy, that would be true. Special knowledge from experts, yes, it would be true. Would it be for speed and efficiency? A delegated legislation. Features of delegated legislation. I don't think it would be for speed and efficiency specifically. The flexibility in the court system, but it won't specifically be flexibility within the court system, right? So I don't believe that one should be involved. Therefore, I guess the best answer, because one is not involved in all of them, that C would be the better answer. Janet owes her cousin Justin 6 months' rent for the apartment she rents from him. Justin wants to recover the outstanding rent and comes to you for legal advice. He is not too keen to take Janet to court, but considers it among his options. His best option is to work out by mediation. Arbitration is a little bit more abrasive, I would say. 16. Which of the following is the main feature of the Commonwealth Caribbean's public law that differentiates it from the United Kingdom's law? Now we have to remember that the United Kingdom has an unwritten constitution, so we have a written one, right? So that would also bring about parliamentary sovereignty. So everything here would stem from the fact that it's a written constitution. Right. 17. Which of the following causes best supports the doctrine of constitutional supremacy over parliamentary supremacy? This would have been Collymore versus the Attorney General. Wonderful. Right. Here we have 18. Judges' security of tenure until the statutory age of retirement is important for independence of the judiciary. Right, remember it must be independent of all other forces, right, as stated by the Constitution. Wonderful. 19. Which of the following philosophers is not associated with doctrine of separation of powers? Confucius wouldn't be. Aristotle set it out, then Montesquieu, then Locke. I hope it's in that order. 20. In all Commonwealth Caribbean jurisdictions, the head of state would be the Queen or the President. I do not believe so. Now, I want you guys to research it. Commonwealth Caribbean states politically, right, are either organized as former British colonies, right, former British parliamentary democracies, right, which are now republics, or current parliamentary democracies. So I believe that, for example, since Barbados gained independence, Barbados got a president, Trinidad got a president, Guyana I think got a president, even though Trinidad's president is more ceremonial, right, which head of states usually are. I do believe that they are still a part of the Commonwealth Caribbean. 21. Which of the following prerogative orders is used to compel mandamus, right, transforms into the word mandate. So you're mandated, you have to do it. Alright. 22. Which of the following are requirements of the operations of the rule of law in any Commonwealth Caribbean state? So the rule of law states that we have to have a Bill of Rights of Man. Constitution providing penalties for criminal. Nope. That is for the legislation. That is for the legislature to deal with. A constitution safeguarded by the independent. True. And you must have constitutional Wonderful. 1, 2, 1, 3, and 4. Here it says 1, 3, and 4. Should be fine. Right? The phase no man is above the law is an attribute of dices, the law and the constitution. Right? So Dicey stated this, no. Alright, Professor Dicey. At a community meeting, one member proposes that the Constitution be amended so it conforms with the constitutions of Commonwealth Caribbean states, in which all parliaments are bicameral in nature, comprised of elected and appointed persons. They would be bicameral in most parliaments are bicameral in nature. Alright, but not all of them unless they follow the Westminster system. For example, I think Guyana is unicameral, so that would be out. So are comprised of elected, right? So elected would be the legislator, right? The lower house, and then the upper house would be appointed, which is also the Senate, right? I believe. So B would be the best answer. But that would mean that Guyana is, it's interesting. A part that is interesting, they're probably speaking about the Westminster system. Alright, let's have a look at this. In a recent case, the Director of Public Prosecutions ruled that a certain public officer should not be prosecuted as there was insufficient evidence. Members of the public are angry at the decision and are clamoring for the DPP's removal. A DPP may be removed from the position in accordance with the Constitution. There's nothing the people can do about that. Right? So it must be in accordance with the Constitution. If the DPP did his or her job, right, and did not violate, right, the Constitution, then it should be fine. I believe it's in accordance with the Constitution. If it is not, then well, if it is not, then D would probably happen, but I believe it's A. The Parliament of a Commonwealth Caribbean state has passed a law which provides for the election of a Minister of Home Affairs who will be responsible for all administration of courts. What kind of foolishness that violate SOP immediately, right? All judges will now have to be no. They write to the Prime Minister stating that this appointment undermines the rule of law. This is ultra virus, so it violates the SOP. 27. The Prime Minister of a Caribbean country state, or a Commonwealth Caribbean state, sorry about that, was charged with tax evasion, found guilty, and sentenced to 6 months in prison. This is possible under the rule of law. All men must be treated equally, right, under the law. We should reserve that right here. Right here we have Mr. Acorn has been acting in the post of Chief Police Supervisor, right, for 10 years and applies for the appointment to his post. The personal officer appoints Mr. Squidward, right, so who is a recent graduate and who got a lower score on his interview than Mr. Acorn, but is a good friend to the personal officers. And which one of these grounds on which of these following grounds may Mr. Acorn seek redress in judicial review? Alright, it can't be that. Infringement of rules of natural justice and legitimate expectation. There is a bias, but let me see. He has been doing it for 10 years. So I think that legitimate expectation should be fine. And the rules of natural justice would outline bias as well. So we're moving with that. Sorry about that. Let me scroll up back. Alright. Here we have which of the following remedies would be available to Mr. Acorn? Would it be restitution? Injunction is to stop something. Specific performance is to have something carried through. Habeas corpus. I believe that the best answer here would either be restitution or specific performance. So I want you guys to look up right, what these different remedies are generally, so you can get a full understanding of where we're coming from. All right, so if we're looking at the law, all right, and we're looking at restitution in law, right, I believe that restitution would speak to the property, right, so the owner of a property. So I don't think it would be that. So I think it would be specific performance. Habeas corpus just doesn't make any sense to me here. The Housing Commission of a Commonwealth Caribbean state acquired the lands of farmers from planters Vale to provide government housing and failed to pay them for the lands. Mrs. Ganga, I guess, a resident of the area, has applied to the Attorney General for leave to file a class action against the Housing Commission, which of the following would not be a requirement for the approval. Is not a requirement for approval of this action. Let me see. Negligence. A good prima facie case. Alright, what does that talk about? Alright, prima facie in law means sufficient, right? Meaning having sufficient grounds or sufficient evidence, right? Or sufficient, when something is sufficient to establish a fact, right? Right, or raise a presumption that unless it's disproved or rebutted, right? So I believe that what would not be a requirement to approve this action, probably it may be correct procedure, but I'm not sure what correct procedure specifically speaks about in this case, right? Because this speaks to sufficiency. These both speak to some amount of helping with local standard as well. So I believe that A would probably be the best answer. Alright. Here now, I can't read that. For rules is most closely related to the question of. I'm not sure what this is saying. Alright. Or one's rules. Not sure what this is saying. Alright. If you guys know what this is saying, could you please state it in the chat for number 31? And then I'll respond. I'll edit the description of the video and tell you what should be there. 32. On determining criminal liability, there must have been on the part of the accused. Right, for criminal liability, there must be coincidence of the guilty mind and the creation of state of affairs. It must be a coincidence of the guilty mind, mens rea, state of affairs, actus reus. Actus non facit nisi mensit rea. Right, remember that. For which of the following crimes is malice aforethought murder, intention to kill? A defense against a charge of murder may be successfully argued on the grounds of a defense against a charge of murder. Self-defense, because I think this is the only full defense. Right, it's a full defense. Everything else is partial. When dealing with a young offender, which form of punishment should a tribunal impose only in exceptional circumstances? Fine, custodial, sentence, community probation order, only in an exceptional circumstance for a young offender. Right? Why would a probation order be? Young offenders go on probations, but what is a custodial sentence? Right, a custodial sentence is mandatory custody of a convict, right? So the custodial sentences tend to be around what? In Jamaica, around what, 5 to 7 years thereabout. Right, so I believe that a custodial sentence would be it. If it's a young offender unless they're defended by gully incapax. I believe that a fine as some service, community service, and some probation order may make sense. But custodial sentence is technically like a pseudo imprisonment. So I think that B would be the best thing there. Only exceptional cases would really do that. I believe so. If you have a different answer, please put it in the comment section. The basic tenet of a criminal law trial is that accidental death of victims may be considered by the court. The court must prove its case of balance. There is no duty to. What do you mean by that? Alright, the onus is on the prosecution, the crown. I'm sorry, I'm getting a little bit too jumpy. Incest does not refer to sexual relations between first cousins, as stated right there. Which of the following is a special defense? Right? So insanity is a very special defense. Right? As it's covered by monotony rules. Right? So special defenses in criminal law, right? These are mental disorders, incrimination. It can be self-defense as well. So a special defense usually speaks to a criminal charge. That in some jurisdiction must declare the court before must be declared to the court before the trial starts. But there are different types of special defenses. There's innocence, constitutional violation, self-defense, and insanity. So I think that these both are special defenses. So I'm not sure what would be the best thing here. But I think that insanity most likely will be proclaimed before the trial starts. Mary stabbed John after many years of physical and emotional abuse. John was rushed to the hospital and subsequently died. Mary is liable for murder. Alright. Why is she liable for murder? Because she will be liable for murder. These are all reduced sentences, therefore you can't be really liable for manslaughter. You have to be liable for murder and then your charge is reduced to manslaughter. Right? D may be held liable even if he considered whether or not there was a risk and concluded wrongly and unreasonably that there was no risk or so small a risk that it would have been justifiable to take it. Right? This would have been the best measure for recklessness. Shamar, Allison's friend, enters Allison's house for dinner. After dinner, he removes his clothing and tells her, "You know what I want." Allison is afraid for her life and removes her clothing. Remember the 4 F's of rape: force, fear, and fraud. Wonderful, so he's guilty of rape. Alex resolves to kill. This shows establishment of a mens rea. Right? Resolves to kill Peter. Injects an orange with potassium cyanide and hides it from Peter with the intention of giving it to him this evening. Peter finds the orange around mid-morning, eats it and dies. Alex is guilty of murder, for he does have malice of a thought, intent to kill. And there was the actus reus, right? There was the actus reus, right? There was death. Right? 43. Brian shoots Marlon in the chest. Marlon has had a prevailing heart condition which speeds up his death. Brian claims he is not liable for Marlon's death. Brian is... we have to look at this. Brian shoots Marlon in his chest and Marlon has a heart attack, right? So we're looking for the but for principle, and if there was actus interveniens, right? Actus interveniens, right? Brian shoots Marlon in the chest, and then he had a prevailing heart condition. But if it was not for Brian shooting him in this chest, would the heart condition would have done this? We could argue that the heart condition would have, allowed his lifespan to be shorter, but it wouldn't be sped up to this extent if it wasn't for Brian shooting Marlon in his chest. So I believe that he's still liable for the death of Marlon, since he must have. Alright? Let me see, he must take the victim as he finds him. Remember that you must take the victim as you find him. Remember that idea that you must take the victim as you find him. So if you take the victim as you find him, and then something else happens after you take the victim as you find him, then there will be actus interveniens. Right, let's move on. 44. In which of the following situations could one be liable for an omission to act? John failed to take care. Does not feed. John's failed to take care of his grandmother. Right, this is a duty to care. Alright, I don't remember the case name for this. I always remember them. I don't know why my brain not working now. Melissa does not feed her newborn. You have that case. Alright, Margaret fails to pay her taxes will go in. Omission to act. Patricia sees a sick man on the. No, this won't help. I'm wrong with that. Alright. You reserve the right not to assist. Alright? So it would be all of these. A party pleading insanity must prove that he or she was absent-minded. No, you must have a disease of the mind. Had an uncontrollable impulse, suffered from a defect of reason, and suffered from a disease of the mind. Wonderful. Well, let me check something. Defect of reason. Defect of reason, I think this would be this. Disease of the mind. So I think C would be the best answer here. So that was Law Unit 1, Paper 1, 2011.